Hi, I'm attorney Gregory Dell, joined by attorney Stephen Jessup, and today we're going to discuss eye disorders and long-term disability insurance claim. And Stephen, in this video, I want to discuss the issues that come up with the many eye disorder type claims that we've handled resulting in long-term disability claims, and I want to provide claimants with some tips and kind of a guide to put themselves in the best position to get approved for long-term disability as a result of an eye disorder. And right off the bat, when a person calls you and tells you they have an eye condition, there's often two types. There's the chronic degenerative type of eye condition, and there's the injury type eye condition, of which I'd say we have a 50-50 mix of clients that we've represented, and they're kind of both handled slightly differently due to the nuances of each condition. But regardless of which one it is, whether it's chronic or an injury, what are going to be the most important steps that a person's going to need to take to put themselves in the best position to get approved?
Well, I'm glad you started with this idea of, is it an accident or is it something that's been ongoing and chronic in nature? Because it will be looked at differently. Now, in starting with the accident, some injury occurs to the eye, it affects vision. I've seen short-term disability claims for detached retinas, various different things like that. In situations like that, your medical documentation isn't going to necessarily be as in-depth as a chronic condition because something happens, you get to a doctor, it's taken care of. So an insurance company is going to be looking for, that limited amount of information, and they're also going to be looking at that claim as something that isn't going to potentially be long-lived. If it's an injury that repair can be done and the person will recover, an insurance company isn't going to necessarily maybe give the same amount of scrutiny as they will in a chronic eye condition, something that you've had for a long time. When you have chronic, conditions of the eye and you start maybe losing sight over time, you're working through it with accommodations, the insurance company is going to look at your medical file. They're going to look at what the problem is, how long you've had it, what type of treatment you've been getting for it, and more importantly, how you've been able to continue to do your job with it. So what happens in the nature of why you're going on disability or looking to file, is it this idea of an acute injury or something happening physically to the eye or a long-term problem you have? It is going to determine how an insurance company is going to look at it. That's why the first question usually is when they say, was it an injury or is it something you've had for a long time? That's one of the first things I want to know because that does set the stage as to how their claim is going to be reviewed.
And so when you have an eye condition, there's usually very often objective evidence of that, unlike many of the other medical conditions that we help people with. Either you have the injury or you have the disease of the eye, and it's often not disputed. So it's a clear situation where they usually agree to the diagnosis. The question is does the diagnosis raise to a level of disability? And what that really comes down to is, what are your subjective complaints as a result of your eye condition? And how do you advise your clients to put themselves in the best position to get their subjective complaints recognized?
Well, subjective complaints, first and foremost, if we always think about this idea that it's your medical records that are going to set the stage, making sure that that information is being conveyed to the doctor, issues you may be having at work due to the condition so the doctor can document it. Because an insurance company is going to look on these chronic conditions, well, you've had it. Like you said, the diagnosis equaling disability. You've had it, so why all of a sudden now can't you do your job? I've represented people, and I know you have as well, who have had serious eye problems and have worked and continue to try to make accommodations and adjustment to the way they do things to continue to work. And that's what we say when you're working for the insurance company, because you, yes, have the condition, but you're proving you're still able to work. So that's where it can become relatively problematic.
And then how important is it to make a very strong presentation of the occupational duties and how that relates to your functional limitations?
It's very. Now, interestingly enough, in my opinion, when it comes to eye conditions, everyone can conceptualize not being able to see in any occupation, right? If you weren't born with a certain visual impairment, it's something that can alter your life in every way, shape, and form. Your ability to drive, to get around, do these types of things. So it's an interesting nuance. It's separate from most other disabling medical conditions when it does come with these visual problems, because the vast majority of work, if you've had healthy eyes and then things have gotten worse, you need to see regardless of the occupation. And a lot of clients I've represented recently, with desk jobs or in front of computers, having to review documentation. I represented an architect who gradually lost his vision, became legally blind at some point of it, and how he tried with all these different magnifications, certain light settings to continue to do the work. And he was able to an extent, but at some point you just can't keep up with it. So, it's really the doctors understanding what you do. Are you doing a lot of computer work? Are you in a factory or a work setting where if you can't see well, it poses a big safety risk? So a doctor understands it, but I do think insurance companies do really understand how important it is to be able to see regardless of the context of your occupation.
And then, Stephen, you just touched on something where you use this word about magnifying glass, special computers, increasing the font sizes of different things, even going as far as another coworker reading to somebody if it's an issue where they have to read, or someone driving for somebody. And there could be a situation where a disability insurance company says, look, we think that if these accommodations were made, you could do your job. But we've had so many cases where the employer says, we're not set up to offer that accommodation. It's not the norm of what we do. We can't offer it. So what is the claimant's chances of getting approved or staying on claim in that situation where the carrier says, do this accommodation, and the claimant's saying, it's not available?
Yeah, well, that's the big thing, right? They can say, well, if these accommodations were available, well, in a perfect world, then maybe, but you're right, it's up to an employer. Is the employer going to give the accommodation? That's always the big thing. It's always going to go back to that. And a lot of times employers don't. Maybe with certain employees, depending on the size of the company, the role within the company, they'll maybe go a little extra distance in trying to help someone get some of those accommodations. But for the most part, you see where employers are like, listen, this isn't something we can reasonably do, and they're just not going to get involved. So if the accommodation isn't available for the employer, the insurance companies cannot use that against you. So I don't think someone needs to necessarily worry about that too much. Now, the idea of magnifying glasses and font size, I'm sure anyone who has a chronic eye condition, who's working and has to read documents and that have done things to try that already. So it's also important to note when you see your doctor, hey, I've had to do these various things just to be able to do my job, to show that you are doing these things. But like you said, getting drivers and having people read, most employers, I would say the overwhelming majority, if not all, would not even consider, making any accommodation to that level.
You mentioned earlier this term legal blindness, which more so comes from the Social Security world and also from like the Department of Motor Vehicles for getting driver's licenses, where most motor vehicle license offices make you take a vision test. And if you don't, and you have to be above a certain threshold, obviously, to drive, or they say you got to go to an ophthalmologist or an optometrist and get approved to say that you can see. But legal blindness has a certain score when you give a test, and it doesn't mean that you have no vision at all. You can still see even though you're legally blind. Do the disability carriers accept this quasi, legal blindness as deemed disabled, or could someone meet the criteria of legal blindness but still not qualify for long-term disability insurance benefits?
Is it possible? Yes, there is that possibility. Say someone's been deemed legally blind for years but continued to do the job. Obviously, they're still able to work despite that. So is it possible? Yes. There's always going to be context beyond that. But in clients I've represented, I can think of off the top of my head, there's a handful over the past couple of years. Normally, once it gets to that level where the vision, drops off that much, the insurance companies, I won't say that they, just get, call, scream defeat and they just approve and there's no issues. But in situations like that, generally speaking, the insurance companies approve They're still going to request all your updates. They'll want to know everything going on with you. But once you get to a level of legal blindness, I think even a lot of the insurance carriers will put that in context and say, all right, well, this person's disabled. They also know, too, that the person's more than likely going to get Social Security disability very soon, so the financial liability to them is lessened. So yes, that legal blindness standard, in my opinion, does have a big impact for the insurance industry in the context of, if you've been working that way for a number of years, then you're going to have a problem because the diagnosis still has to equal the disability. And I have had clients, and under certain policies, especially individual policies that you purchase on your own, you have presumptive disability provisions where, blindness, loss of sight in both eyes, and they use legal blindness, is presumed to be disabling, and a benefit is paid under presumptive disability. And I've had clients receiving that benefit while still doing their job duties on a lessened level, but they're not reviewing it as partial disability. They're treating it as a total disability due to that legal blindness.
Another challenging aspect is especially, there's two, mostly in the chronic conditions, that often macular degeneration, conditions like that, where they've had the diagnosis for many years, and they go back to the doctor and they say, I'm starting to have more difficulty focusing. I'm seeing things, but now I'm starting to get headaches, or I'm getting halos, or I'm starting to get more pain than I used to have. But objectively, the diagnostic medical notes that the doctor's taking are remaining the same. And so the disability carriers look at it and go, well, we don't see any objective change in your testing, therefore you're not disabled. And Stephen, when we look at these, the ophthalmological, I'm not good at pronouncing that word, but those medical records those are some of the most complex records of any that I see. I mean, without the team of ophthalmological experts that we have to help advise us, or consulting with their own treating doctors, you can't understand them. I mean, you see the charts and you see the numbers, and it's not like any of the other medical conditions we have where you're evaluating what they are. So for the insurance companies to get an expert to look at those particular objective data and then give feedback on it, it's kind of like, I don't want to call it fraudulent, but it's like, it is what it is, but the person's subjective complaints are what matters at the end of the day. So how do you advocate for the client who doesn't really have a change in their objective evidence from the test 6 months earlier, but now gets to the point where it says, I can't do it anymore?
Well, you got to do, like you said, you got to go with the subjective complaints. Hopefully those are being documented in the medical file. And if the doctor is willing to agree that, even though objectively speaking, the testing hasn't changed, it is reasonable this person would have these problems, start to experience these problems more. And then it's also then too taking that and working it towards work. Is the work product slowing down? Are you having issues at work? Have you been under performance evaluations? Things like that to show that something is going on that correlates, with what the person's complaining of and saying. So every case can certainly be different, and there's nuances to each of them, but it's pulling in all the different sources of information to paint a broader picture than just what that objective testing may show. It's the same when we see MRIs. You can have minimal findings on an MRI, but that doesn't mean that the person's in a great deal of pain. So it's kind of the same idea of looking at everything to create a picture, where an insurance company may just try to focus on one small portion, of this testing to understand what they're looking at.
Right, and it's like every doctor says, look, I don't treat the chart, I treat the patient. Mm-hmm. And when we present claims on behalf of our clients, we're not presenting the chart, we're presenting the claimant, the human, the individual, the difficulties that they're having, and conveying why they can't do the duties of their job or any occupation, depending upon what the definition of disability is at the time. What I encourage you to do if you have an eye disorder or any other type of medical condition that's disabling you is to reach out to Stephen, myself, any of our disability lawyers. We're always going to provide you with an initial free consultation. We're going to ask you to send us a copy of your disability policy or a copy of your denial letter if you've been denied. We'll immediately set a phone conference and let you know how we can assist you. We also want to encourage you to spend some time searching our website where you can look up your company, your medical condition, your occupation. And by doing that, you're going to find a lot of helpful information where we've summarized cases that our lawyers have handled, lawsuits across the country dealing with your specific medical condition or your insurance company, reviews about your company, questions and answers about your specific medical condition or your company. And all of this information, while it may be burdensome for you to look at, is going to educate you and put you in the best position possible to understand how the disability insurance company thinks. When you understand how the disability company thinks, you're going to be able to play this game. And I hate to call it a game, but you have to know what their next move is going to be and what they expect you to have in order to keep yourself from being denied benefits. So no matter where you live in the country, our clients are located nationwide. We look forward to assisting you in the future should you need us.